Evicting a tenant can seem like a complicated process, but in this video we'll quickly explain the eviction laws in Oregon and outline some simple steps that landlords can take to initiate an eviction. In this video, we'll talk about what the eviction process looks like, how Oregon laws affect evictions, and how to legally remove a non-compliant tenant from a property. Be sure to watch to the end of this video to find a link to a fillable eviction notice that meets Oregon requirements, but that you can customize to meet your needs. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks on a property or physically remove a tenant from that property, even if the tenant has not paid rent or violated obligations in some other way. If the tenant refuses to leave after violating the terms of a lease agreement, a landlord must seek an eviction from the court. Eviction is different from the simple termination of a lease. A landlord can opt not to renew a lease after the specified term has ended. There is no need to involve a court in this process. If a tenant in Oregon fails to pay rent or breaches the terms of a lease agreement in some other way, the landlord can issue an eviction notice. There are 4 versions of this form. We'll go through each one so that you know which one fits your situation. One is the 24-hour notice to quit. This form gets used if the tenant is found to be dangerous to the property or other people, or if the tenant is found to be engaging in illegal activity on the premises, such as the distribution of illegal drugs. The notice orders the tenant to move out within 24 hours or face an eviction proceeding in court. Another version of the eviction notice is called the notice to quit for non-payment of rent. According to state law, the landlord must wait until 5 days after rent is due before issuing this notice. If the landlord gives the notice on the 5th day after rent is due, then the notice will give the tenant 6 days to either pay rent or face eviction. The window of time the tenant has to rectify the problem shrinks based on how long the landlord waits to issue the notice. If the landlord gives the notice on the 8th day after rent is due, then the notice will give the tenant 72 hours to either pay or face eviction. This notice to quit must specify the amount of rent that must be paid and the time by which the tenant must pay in order to cure the lease violation and avoid eviction. Another version of the notice to quit is called the notice to quit for non-compliance. This gives the tenant 14 days to fix the problem identified in the notice. The notice says that if the problem isn't fixed by the end of that period, then at the end of the 30 days, the tenant will face eviction. If, however, the notice relates to the second similar violation within 6 months, then the landlord can legally cancel the lease and require the tenant to move out within 10 days. Still, another version of the notice is called the 30-day notice to quit. This one gets used to terminate a month-to-month tenancy and tells the tenant to either move out in 30 days or face eviction. If the tenant has lived in the property for more than a year, then the landlord must give 90 days notice before choosing not to renew the lease. The landlord must serve the appropriate version of the notice to quit on the tenant, either in person or via first-class mail. Per state law, if the notice is served by mail, the minimum period for compliance is extended by 3 days. The notice should reflect this extension. If the landlord and tenant have previously agreed in writing to other forms of correspondence, including electronic forms, then these may be used to serve the notice. If the tenant does not respond to the notice to quit within the allotted time period, then the landlord may file an eviction action in the circuit court in the county where the rental property is located. In order to do this, the landlord will file 2 forms, known as a residential eviction complaint and a summons. The complaint details the nature of the lease violation, and the summons is the court's means of setting a hearing date. The landlord should also file a copy of the notice to quit that was served on the tenant together with the complaint and summons. The fee for filing all of these is $88. Once all relevant paperwork have been filed, a court clerk will issue copies of both the complaint and the summons to the landlord that must be served on the tenant by the end of that day. After receiving the complaint and summons, the tenant can file a form known as an answer to a residential eviction in order to register a counterclaim. Both parties should attend the hearing on the date set out in the summons. If the tenant fails to appear or if the court rules in the landlord's favor, the court will issue a judgment. This can be used to authorize an officer of the law to remove the tenant and the tenant's possessions from the property. We've got everything you need to get eviction proceedings going in Oregon, from eviction notices to court documents. Click the link below to find the form that meets your needs. And also, don't forget to subscribe to find more videos about legal topics in business, real estate, and more.